morning. Good morning. Hello, everybody. Hello. Welcome in. Welcome. Welcome, welcome. Hello, hello, hello. We're going to kind of do a Q&A on this new motion rather than just reading it, everybody. So we'll kind of work through it together. Good morning. Good morning. How's everybody doing today? Good morning. Yikes. Hello. Hello, Paris. Good to see you. Good morning. Hello, Suze. Good to see you. Hello, O from Florida. Nice. Chella. Hello. Good morning. Hopefully I've said your name correctly. Good morning. Hello, hello, hello. Or good afternoon. Or good evening. Hello, Mads. Oh, no. You're up early. Good morning. Good morning. Hello. Oh, Baltimore. Yes, that's an ongoing situation there. So it is very sad. Very, very sad. Not much information's coming out. Good morning from Colorado. Hello, Rhode Island. Well, hello. Rhode Island, you know, you're really small, but very powerful. I respect that. I can respect that about you. Oh, Iowa. Oh, hello. Hello, Lynn. Good morning. Welcome, welcome. So, good morning, everybody. I'm on just a bit early. This just was working for my schedule today. Hopefully everyone will be okay with that. So I've got, Georgia, New Jersey. So this morning, this was just filed, and I've gone through it enough to know that I think the best format's to do kind of a Q&A regarding this particular motion. Good morning, Cecilia. Hello, hello. So this was just filed today, everyone, and this is the, let me just get my markers out. We'll mark it up together. Somehow we'll make it through. Oh my goodness. Hello. Oh, hi-oh. Hello. Welcome. Welcome, welcome. So this is the District of Columbia case, right? So this is the federal case. Now, just recently, I had gone through Jack Smith's motion in limine, or lemone, which however you want to say it. So we just went through this just a couple days ago, starting my day off. Oh, well, hello, welcome, welcome, welcome in. So this is the motion in limine, right, that he filed. And I went through this. It took a couple of times, but I did go through this full document here. Good afternoon. Good to see you from Dallas. Nice. Good morning. So I went through and, you know, we talked about what a motion in limine is and that you can ask the court to exclude certain evidence so that the jury doesn't see it because there could be an evidentiary rule issue going on. So we talked a little bit about the rules of evidence. I'm kind of working on that series along with the rules of criminal procedure, and I'm starting that series probably today. I think I'll post the first one on that today. So what has happened here, everybody? We had a motion in limine that was filed, and we have this footnote, and according to the footnote, it says, and this again is the government, so it says the court has determined that the deadlines in the pretrial order are held in abeyance, while the defendant's appeal of denial of certain of his motions to dismiss are pending, right? So we are in the, we have appealed, or Trump appealed to the DC Circuit. Nonetheless, to provide the court and defendant notice and to promote the prompt resumption of the pretrial schedule if and when the mandate returns, the government will continue to meet its own deadlines as previously determined by the court. Now, this was filed December 27th. We have a response now to this motion in limine, kind of a response. Hello, good morning, good morning. Oh, thank you for the roses. Oh, I appreciate that. So this is just absolutely wacky town here, everybody. We've gone to Wackyville because what we have is President, you know, it's his own motion because he puts the word president in front of his own name. So this is Trump's motion and it's opposed. So the government disagrees. That's what opposed means here. Good morning, morning star. Hello, hello. So he's filed this opposed motion for an order to show cause why prosecutors should not be held in contempt. So he's he's asking for Jack and his team, because they filed this motion and continued on with their discovery obligations. He's asking for sanctions. Can you even believe it? Good morning. Hello, hello. So, oh my gosh. All right. So, there's so many things going on here. Again, I just can't even bring myself to fully read through these motions when they are just completely bonkers. So, but there are a few pieces in here to take a look at. So, it's an interesting question. We've got several things going on here. We have the DC Court of Appeals, who are going to hear arguments in court. They've been briefed. They even have multiple amicus briefs, and they've set it for oral arguments coming up on the 9th. So just in a few days, they're going to be hearing on it. So they're deciding this issue on whether or not presidential immunity governs presidents committing criminal acts. Whatever. So that's kind of what's going on with that case. We have an amicus brief that says, great, Court of Appeals, look, you don't have jurisdiction because it's an interlocutory appeal. We went all through that last night. Now this morning, oh my gosh, this guy files this motion for sanctions because the government has filed a motion in limine and have gone forward on discovery. So pseudo motions. Oh my gosh, Blue nailed it. Exactly. Discovery. So pseudo motions. Oh my gosh, Blue nailed it. Exactly. Former president officially criminally charged in all these jurisdictions. So it's unprecedented. Oh, we're glitching. Oh no. Oh no. Is it the trolls? Are we getting hit by trolls, everybody? Hold on. We should be okay. How are we better now? Everyone's doing the locomotion. What causes that? Usually when I get reported, it starts lagging pretty hard. Okay, we're better. Good. All right. So very good. I wasn't sure where I left off here. So you'll have to, when did it all go awry, everyone? Okay, good. Are you going to be going over? Okay, so yeah. So before I even get into that, John and anyone else, we're at about 350 people. Welcome in, everybody. I have gone through and I've taken a look. Now you have to understand as a quick side note, everyone, let me just make a note about what I'm talking about here. So let's just write down the topic so we remember. Let's just take a sidebar for a minute. All right. So, I'm going to spell his name probably wrong and I don't care. So listen, all of these documents have all been on file. I've looked through these documents over years, and so there's nothing new. There's no new information other than the names that had previously not been used are now available. Now, for me, I'm not really that interested in the names. I think it's interesting and important to bring this topic up and talk about this case. But if it's just for kind of like a shock and awe situation, that's just not my cup of tea. I'm not a shock and awe person, everybody. So if I had people who were saying, wow, I really want to know the details of this case. How did this happen? What was the settlement? What did she agree to? What was discovery like? If we've got questions about the proceeding on the civil case or the criminal case, that's one thing. But if we just want the names of court documents, of people in court documents that have already been on file for years that nobody seemed to care about before, that's probably not something I'm going to be touching on anytime soon. That's kind of how I am. I think it's very important information, but I think there are so many places covering that information where there's just good sources out there other than me in order to locate that information. I find the content of these documents to be incredibly disturbing. I found them disturbing when I read them years ago, and I find them even more so when I read them again last night. It's just horrible. It's horrific situations. and just completely heartbreaking and awful, and something that should absolutely be in everybody's mind right now, absolutely, and the press should be covering it, and everyone should be getting their information. But for me and how I try to help out here, I find that it's more helpful, my knowledge of how the system works and the process works, rather than just going through and putting names to documents that were already out there. So that's kind of how I view it. Now, I think it's important, everyone. I know Under the Desk News has been doing a series on it. I know there have been, here on TikTok, I know there have been multiple creators going in and pulling those names and giving that information. And I think that's great. I'm in full support of that. I think that's fantastic. It's just not something that I am going to be doing. So I just think because it's incredibly important information, but because of that, there's also a ton of sources out there that are really valid. So for me, I think I'll kind of keep moving on with the topics I've already got. I did do a post on it, so you can look up the criminal case and you can look up those different documents. So again, if we've got questions on motions to compel discovery, or we've got questions on, what exactly a settlement means or how to go about that, that's really more my area, as opposed to kind of getting into the details involved in these documents and the names involved. It's incredibly important. It's valuable information, but I think others can handle that information a bit better than me. Has a ton of resources under Linktree if anyone wants. Oh, excellent, Mads, excellent. I think it's really great. Again, I think this information is valuable, but for me, I will. I'm kind of going to step aside and deal with more of the legal questions as they occur regarding this, as opposed to really going through the documents and kind of reliving it. Because if you have already been through these kinds of documents and you've read through these documents and you've had to live with these documents in your mind for years, it is reliving it. And, that's not a very pleasant place for me to be. But people who have no knowledge of these documents, I think is incredibly important to get that knowledge from valuable sources. So that's kind of where I'm at. Attorney Jaguar is one creator. Excellent, excellent. Yes, and again, if anyone, let's just take a minute. If anyone's got suggestions on different creators that are going through these documents or explaining the different stories here, everybody should have their voice heard. I think that's incredibly important. So go ahead and add the suggestions in the comments even right now if you feel like it. So yeah, I think it's incredibly valuable information, everybody. I just don't think that I can contribute to this discussion in an academic way that would be of more assistance than what is already going on out there. I've been reading the files since last night. Yes. And see, again, this case has been going on for years. So many of us in the legal field, particularly those of us who have dealt in this area of human trafficking, we have already been very familiar with this information, and so none of this is new. We already knew pretty much who the people were as well. So the names are fantastic to be made public, again, for acknowledging and accountability and understanding how everything happened. But for those of us that have been kind of swimming through this for years, it's just at this point not particularly something that I personally want to really go through again. Files in a Linktree. Yes, excellent. Love it. Yeah, again, and there's documentaries. And it's valuable, everybody. It's valuable. It's just, for me, it's one of the topics that I have, again, after reviewing it again and reviewing the information, just for me, I don't find myself really wanting to walk through that again, only because I've been there for years already. So I think, will the monarchy be prosecuted as well for Prince Andrew? That's a great question, VR, actually, with Prince Andrew. Yeah, I think it's really important for his name to be back out in the bright spotlight again. I think some things were done originally, but it's faded over time. So if we keep putting everything in the spotlight, that's when accountability happens, and that's so important. So important. New nails. Yes, indeed. And it's important to know not every name is someone Right. There's a lot of nuances. There's a lot of nuances. So, you know, as you go through and fact find everybody and do your research, I think that first of all, if that's something that you think is important to you, again, I've done a post on picking your top topics because we can't do everything. But if that's one of your, top 10, go for it. Just dive in. I think it's incredibly valuable information to know what's happened here. But for me, I've decided to go ahead and put it to the side on my particular channel. They already made a deal with the monarchy. Could be. Again, I don't really have a lot of misinformation too on it. Yes, absolutely. Yeah, Cecilia, there's a lot. Now, again, if you go back, and just a couple of days ago, everyone, I did post a post explaining the lawsuit briefly, but also giving you the case name. So if you really want the actual information, like the true information, I understand all the names are plugged in now, but if you want to see the court documents, they are available online through that case number, and they've been available online. So you can pull them up and take a look. Michael Jackson's on there. Well, yeah, I mean, there's a lot. And, again, for those of us who have done any kind of work within the human trafficking area, this is, again, kind of old news for us. So, and I try to stay a little bit further away from some of the more difficult topics that I have been involved in over the years, just in order to, deal with it. So with that will be my final thoughts on that, everybody. So if anyone is asking, or if there are any comments coming in on that, feel free to just kind of spread the word that I'm just really not going to be addressing that. I think there are plenty of other people doing that. I'm in full support, but just personally will not be going down that road. So that takes us back then. A lot of people named were involved. Yes, so I think, again, right, go do your research. Absolutely important topic. I'm not moving on because it's not important. I'm moving on just because there's a lot of very important things going on. So with that, everybody, hopefully, of course, I mean no offense to anyone, but it's just, for me, not a road I'm ready to go back down again right now. And again, there are plenty of documentaries on this very issue that have been going on, and cases as well. And the last case of the human trafficking that I was actually actively involved in was in 2017. So it's just too fresh for me. All right, here we go, everybody. So let's get into this. And with that, we will turn a 90-degree angle here. Oh my gosh. We'll turn, everybody, we're turning back to a crazy land, a different kind of wacky crazy. Here we go. Okay, so again, I read what's here, and so that's how we know it's his filing. Now, as I had said, the government had filed this motion to eliminate. Now, if you remember when I first started reading this, I made a comment that said, I'm not sure why he's filed this because we're stayed. And then we have this little footnote here saying, you know what? I just want to keep filing. I want to stay on target. Now, for me, again, there's several things where I'm like, well, all right, then, if nobody disagrees with it, then why not? But apparently someone's disagreed. Does it rise to the level of sanctions? I don't think so. But, that's how the defense team's working here. You could just say, in a motion, you could just clarify, hey, we just want to clarify we're not going to be doing any of this stuff. And the court can be like, agreed, rather than saying we need sanctions here. Because, this is just rude, in my opinion. It's my opinion. It's a bit rude. The other thing, too, that's completely bonkers, everybody, is when we have a stay going on. Typically, discovery can continue to go on. It's controversial. There's no hard, fast rules. There's no rules in the rules of civil procedure here, so we're kind of in the administrative role. But there are no procedural rules regarding whether or not discovery can continue when there is a stay. So it really depends on the discretion of the judge. So it's up to the judge under those general rules on how we do that. It's different. Oh my goodness. I don't even know. So anyway, let me take you through a little bit of this and let's kind of, smack this around a little bit. Oh my gosh, and see what's going on because it's ridiculous. It was just filed this morning. I understand what he's saying. And, honestly, I don't know about the motion in limine. I don't know. I was surprised that Jack had filed it, but is it inappropriate? I really don't know. Should he be sanctioned? No, that's ridiculous. But what about discovery? Now that, on the other hand, should that continue to go forward? Well, in a case like this, I don't know. I think it probably should. But again, that's my humble opinion. So let's just take a look again. I'm going to kind of hunt and peck through here. So Trump respectfully moves this court for an order to show cause why prosecutors Smith, Gaston, and Wyndham, collectively the prosecutors, should not be held in contempt for violating the court's order, staying any further proceedings that would move this case towards trial or impose additional burdens of litigation on defendant. So, and they are citing the stay order. So just so you know, that's this order here. And this order is 3 pages long. It's, not very detailed. There's not a lot of information. And that's literally all the judge is saying is any further proceedings that would move this case towards trial. So that's proceedings. And I'm not sure a proceeding is a pleading. I mean, if you're technically looking at it, is a pleading a proceeding or is a proceeding a hearing? Right? So that's one thing that's messed me up is she's saying, look, we're not going to have any proceedings. I'm like, well, that's not a proceeding. That's a motion he filed that would move this case towards trial or impose additional burdens of litigation on the defendant. Now, what are additional burdens of litigation mean? What does that mean? We don't really know. So it's kind of a mixed bag here. I think her wording is very broad. I don't see how Jack's motion in limine or eliminate in his discovery would violate the order that she set out if the defendant wants clarification, ask for clarification. So, and hopefully she will clarify so everyone kind of knows what's going on. Yeah, I think proceedings are trials and hearings. Well, yeah, I mean, I've only been an attorney for a long, long time, but I don't think I've ever heard of a motion considered a proceeding. So there's that. Yeah, not paperwork. Exactly. Or the discovery. Exactly. So, again, the discovery is not filed with the court either, but there's this idea of burden of litigation, which comes out of a particular case, but again, is not well defined. So we're not sure. So let me take you through the introduction here. Again, I won't be reading this entire motion, but the state order is clear, straightforward, and unambiguous. And that's, I wouldn't say that's true. This is it. I don't know. Is this ambiguous? It might be. All substantive proceedings in this court are halted. I didn't say substantive proceedings. Despite this clarity, the prosecutors began violating the stay almost immediately. First, within 5 days of the court entering the stay order, the prosecutors served thousands of pages of additional discovery, together with a purported draft exhibit list. All right, so let's just note what he's upset about. He was given discovery, and he was given a draft of an exhibit list. So he's been given information on the government's case, and he's upset about it. Oh my gosh. So I don't know. I mean, they're asking the prosecutors to be called out for this. So, I mean, everything's a delay, but not sure. This may have a little bit of malice involved in it. Upset about getting evidence. Yeah, stop giving us evidence. Oh my gosh. All right. Through counsel, Trump advised that he rejected the prosecutors' unlawful productions, that their actions violated the stay order, and that he would seek relief if their malicious conduct continued. So they gave additional discovery, a draft, not the actual list, but a draft of the list, and he's claiming it's malicious conduct. They do have to show discovery, but how discovery proceeds when there's a stay going is up for debate. And it's really, it can go either way, and it depends on the judge. That discretion's given to Judge Chutkan. So the question is whether or not discovery is being stayed by Judge Chutkan. And I don't see that in her order here. Everything I know is from my cousin Vinny. Well, I mean, that's about where we're at. So let's take a look here in Judge Chutkan's order to stay. All right, so we've got an appellate jurisdiction here. Let's look and see if she's got anything in here about discovery. So DC Circuit recently made clear absolute immunity constitutes an entitlement not to stand trial, which is the issue that's being dealt with in the amicus brief, right? Do you have that right to not stand trial? We don't know. We don't know how that goes. Whether litigation may go forward in district court, right, is what the Court of Appeals. So the court agrees with both parties. Defendant's appeal automatically stays further proceedings that would move this case towards trial or impose additional burdens on litigation on the defendant. So we're citing this. This is it. This is all she wrote, people. This is it. Oh my gosh. Let's just highlight that. I mean, and yeah, I don't think it's the judge's fault. We're just, I mean, who would have thought a defendant's like, keep your evidence. We don't want it. I've never heard of that. Accordingly, and for clarity, the court hereby stays the deadlines and proceedings scheduled by its pretrial order as amended. So the deadlines could go for the motions. So those deadlines could be paused, but does that mean then you can't file the motions, or you just aren't? Like, how I read this is that then the defense doesn't have to respond within a certain period of time or lose their ability to respond. So, that was one thing we were talking about when I was going through that motion in limine was, hey, when does he have to respond? Does he have to respond? Well, everything's paused. So, technically, no, it seems like her deadlines are stayed, but that doesn't mean he can't file them. The deadlines mean the dates. Right, exactly, everybody. Yep, you got it. So I'm not sure this means you can't file stuff. Now, should he have? That I don't know. I can't answer that. The federal courts are kind of a mixed bag on whether discovery continues with a stay, but I'm not sure there was a malicious intent involved. The court emphasizes two limits on that stay. Again, this is the court. First, as defendant notes, the stayed deadlines and proceedings are held in abeyance, and rather than permanently vacated. If jurisdiction is returned to this court, it will, consistent with its duty to ensure both a speedy trial and fairness for all parties, consider at that time whether to retain or continue the dates of any still future deadlines and proceedings, including the trial scheduled for March 4th. All right, that seems pretty clear. Second, the court does not understand the required stay of further proceedings to divest it of jurisdiction to enforce the measures it has already imposed to safeguard the integrity of these proceedings, including defendant's conditions of release, the protective orders governing discovery materials. So we do have a mention of discovery materials because there's a protective order in place. So the protective order is still in place, and she's still keeping jurisdiction over the protective orders over discovery. So that logical analysis would lead me to believe that she still has jurisdiction over discovery, right? If they aren't asking for responses. I would agree, Jennifer. I would agree. Said anything moving towards trial. True, but she also said she's retaining jurisdiction over protective orders governing discovery materials, and isn't specifically saying discovery is stayed. The restrictions on extrajudicial statements as modified by the DC Circuit's opinion in US v. Trump, and protective jury procedures. So she's holding on to bits of her jurisdiction here and is making that very clear. So that part's clear. And then, unlike, for example, requiring additional discovery or briefing, maintaining those measures does not advance the case towards trial or impose burdens of litigation on defendant beyond those he already carries. So let's break this sentence apart. I think this is the key here. Unlike, right, requiring additional discovery. So there's no requirement for additional discovery or briefing. There's no requirement. Maintaining those measures does not advance the case towards trial or impose a burden of litigation on defendant beyond those he already carries. So continuing to give him evidence when evidence has already been given to him could be seen as a burden he already carries, not an additional burden. That's how I would see this particular argument going. I don't think we're adding to it. Maybe quantity, they're saying, well, the quantity's adding to it, perhaps. But the quantity of discovery has been the big issue in all 4 of his cases. So I agree. Excellent. Thanks, Jennifer. I really appreciate your comments. Very helpful. And if a criminal defendant could bypass those critical safeguards merely by asserting immunity, then appealing its denial, then during the appeal's pendency, the defendant could irreparably harm any future proceedings and their participants. So I think this is really the key piece that I'm going. Now we'll go back into Trump's motion and see if he's pulled this apart. So let's take a look one more time. Anything else on discovery in here? Little precedent guiding the application to protective measures, motion to enforce, right, back to the district court, jurisdiction over the merits of the decision. District court's not been divested of jurisdiction over ancillary matters such as protective orders. So, that's the other question. A protective order on discovery is an ancillary matter. So would the discovery then also qualify? We have a case here. Parties have not identified and the court is not aware of any guiding precedent in the circuit at this time, much less instructive cases in the context of interlocutory immunity appeal. And that's a very specific type of appeal. In addition, defendant does not appear to argue that the protective measures are themselves stayed. So he didn't ask for those measures to be stayed, so they weren't. Also, it wasn't something that was debated. Thank you for going through it thoroughly. Oh, absolutely, absolutely. Nonetheless, if he asked the court reviewing his immunity appeal to also take temporary jurisdiction over the enforcement of those measures, and the court agrees to do so, this court, of course, will be bound by that decision. So she's saying he can ask the appellate court to take over the jurisdiction that she has kept. So I think that's really important to note, everybody. This is how we're agreed in part, granted in part, not granted in part, or denied in part, which is really what one of Judge Chetkin's ways of doing things, which, I think is great. I think she's really weighing everything out. So on the one hand, she's going to stay the case, but on the other hand, she's keeping jurisdiction over protective orders governing discovery material, along with the other pieces that she had set into place. So she's got jurisdiction already in place over certain bits. So technically, I think discovery would be included, but that's my thought. That's what she can argue. So let's go back into Trump's motion, everybody, and see if we can find this particular argument. So again, let's review that real quick. Unlike, for example, requiring additional discovery. So again, requiring additional discovery, that word's important, or briefing. Again, requiring briefing, maintaining those measures does not advance the case towards trial or impose burdens of litigation on defendant beyond those he already carries. So again, this could be, I guess, an issue of quantity, but that seems like, this isn't the Florida case. We're not dealing with that in this particular case. So let's go back into his motion here. Thank you. So again, so he's saying his problem. So first of all, they were given thousands of pages of additional discovery, number one, and a draft of an exhibit list, which they refused. All right. So they said, we're not going to take that because it's, malicious conduct. Well, thank you, David. Good morning. Good to see you. So that's malicious conduct. So ignoring the warning, the prosecutors filed an expansive motion in limine. In less than 10 days later, the document teems with partisan rhetoric. Oh, I just don't even care to get my red pen out anymore, anybody. This is at the point now where my red pens are running out of ink, including false statements that President Trump propagates irrelevant disinformation. Well, I think that one's okay. I think that's an okay argument as an attorney, both within the courtroom and outside of it. Moreover, the motion in limine mirrors the Biden administration's dishonesty talking points. Oh my gosh. So then now we're back into, come on. Asserting again falsely that President Trump was responsible for the events of January 6th, when in truth he called for peaceful blah, blah, blah. In this matter, the prosecutors seek to weaponize the stay. Oh my gosh, everybody, we're weaponizing a stay now. Everything's getting weaponized. Yeah, I'm going to have to weaponize my red pen. Everybody, we're weaponizing the red pen. What? Here it goes. Oh my gosh, to spread political propaganda. So I'm like, have you looked that up? Knowing that Trump would not fully respond because the court relieved him of his burdens of litigation. Well, only partially. Knowing that Trump would not fully respond because the court relieved him of his burdens of litigation. Well, only partially. Gosh, lagging. No, we'll wait. We're waiting on the lag. Are we back? Okay. Are we back now? Weird glitch. Yeah, sometimes we get reported, everybody. Yep, we're back. Okay, we're good. Great. So I've got a kind of a red flag that's coming up, so I'll be able to pause when that does happen again. Seems good now. Boost. Okay, excellent. Yeah, just give me a heads up if that starts happening, and I'll just pause for a minute. All right, so here we go. Again, we're talking about the ethical rules here. All right, misconduct, indefinitely, effectively converting the court's docket into an arm of the Biden campaign. All right, so this would also be, is that a fact or is that in law? So if not, again, are we dealing with a bad faith argument here? To remedy this outrageous conduct, the court should issue an order to show cause why the prosecutors should not be, 1, held in contempt. So contempt, again, is where you have violated a court order. So kind of like the court order in the New York civil case where he said you're not supposed to talk about the people who are in the court process, and he did. So he was supposed to be, technically could have been held in contempt, but instead he was just sanctioned. Number 2, required to immediately withdraw their motion in limine and improper productions. What? I don't even know what that is. I've never heard of that before. 3, forbidden. Oh dear, forbidden. What? Now we're in a novel. Now we are in a we're in the forbidden forest. From submitting any further filing or production absent the court's express permission while the state order's in effect. What? Okay. So I'm going to call this I'm telling mom. Mom has to pre-approve everything before you can file it. Oh my goodness gracious. And 4, assessed monetary sanctions in the amount of President Trump's reasonable attorney's fees and expenses incurred in responding to the prosecutor's improper production and filings. This is almost a direct quote out of the orders where his attorneys were sanctioned in Florida and New York. So good for him using that language again, including in litigation this motion, respectively, the requested sanctions. Okay, so sticky note. Yeah, I should get one, shouldn't I? I'm not quite as organized today, everybody. So he's asking for money using the same language that the courts have used to go after his attorneys. So I think that's great. Great. Wait until you get to the part where they claim the court doesn't understand. No. All right, everybody, give me 1 second here to get my I call it a scuttle, but I'll get my little Post-it up here. I'm still trying to figure out how to post something on the live for people to read. So So if anyone can figure that out, I've tried to put a sticker. Yeah, I've tried to put a sticker on, Sarah. I can't seem to get it to work for some reason. I'm going to need to have a tutorial. The court order says the discovery. Right. Well, the court order says they still have jurisdiction. They didn't say whether discovery should continue or not continue. They just said that their jurisdiction over the protective order regarding discovery was still in place. They can't be real lawyers. Well, at this point, I think a lawyer is just a very broad term for people who've had to pay to go to a particular kind of school. All right. So let me write this out. I've got some sass this morning, everybody. I've not had enough coffee. Forgive me. Sorry about that. A little extra sassy. Well, that didn't come out right. Oh, my goodness gracious. Okay, here we go. Just a minute. Oh, my gosh. Love this. Well, I think it's because I was going through all of the Epstein paperwork last night. All right, here we go, everyone. So what I'm reading through here is USB Trump. This is the DC case. And this is defendants' a motion for sanctions. Okay, hopefully that's clear enough. We love oh my goodness gracious. All right, so here we go. Hopefully that's good enough at least. Dark. Oh my gosh. Yeah. All right, so where did my red pen go? Hold on. Tap the text box and the A symbol above it. Okay, hold on. Let me just see here. Oh no. Nope. Oh my goodness, everybody. Seriously, I just don't even. All right, give me 1 second. I'm gonna try this, Suze. We're gonna do this together, okay? We'll do this together. Wait. It has the A symbol. All right, hold on. Okay, I'm gonna give it. Okay. Okay. Oh, I can't do it. It's too much, everybody. It's too much. It's too stressful. I'll come back to it. I'll come back to it. We'll come back. Type in your text. Yeah, so I'll come back to it. Oh my gosh, we can try later. Yes, Suze, I'm just, yikes. I will work on it. I've got to work on my tech skills. All right, so here we go. We're fine waiting. Oh, you're so sweet. All right, next time, everybody. That was my 30 seconds effort, so we'll go forward from there. Here we go. Again, a motion for sanctions here. So he's saying court fees or attorney's fees. So here's the background we're putting into place. A sticky note. I'm here to help. Oh, Suze, you're so kind. Oh, no, I appreciate it. I appreciate it. Sometimes it's hard for me to see all the details of what's going on my screens, so it takes a little extra effort. Background. This case presents weighty questions of first impression concerning the scope of presidential immunity and the impeachment judgment clause and double jeopardy. All right. He moved to dismiss on other grounds. We all know that. I'm going to skip through this background here. The entire case is essentially involved in the appeal, and that's, debatable again. In response, prosecutors agreed that while the appeal is pending, the defendant will not be subjected to the burdens of litigation, but improperly suggested that the prosecution can somehow continue to shoulder its own burden and advance the case in President Trump's absence. I think that's a stretch. All right, that's a stretch. But I think it's okay to have an argument that's a stretch. It doesn't seem to be, there doesn't seem to be any malice in that. I think that's a valid argument. So I'm going to give that one an okay. Red stamp. Oh my goodness. Oh my goodness. All right, next up here, all right, the prosecutors further invited error by suggesting wrongly that the court could make headway on motions despite its lack of jurisdiction. I think this one's okay too. You know, sure, go for it. Is it true or not? I don't know, but I think it's okay. The court rejected this unprecedented and unlawful approach and instead stayed any further proceeding that would move this case towards trial or impose additional burdens of litigation on the defendant. So unprecedented, unlawful approach, I would take off points for that because I think that that's just rude and unnecessary. The court expounded its stay to include all deadlines and proceedings scheduled by pretrial order as amended. That's true, and we just went through that. So again, remembering how Judge Chuck can put out here, everyone, let's just remember exactly what she said. So it's so important. The court emphasizes two limits on the stay. So first, as defendant notes, the stay deadlines as well, rather than permanently vacated, they are held in abeyance. If jurisdiction is resumed in this court, it will, consistent with its duty to ensure a speedy trial and fairness for all parties, consider at what time, whether to continue the deadlines here. So this is the first piece, all right? So first of all, deadlines. And then here's second, the court does not understand the required stay to further proceedings to divest it of jurisdiction to enforce measures it has already imposed. So this, I think, is really the key piece here. Here we've already got whatever's already in place can continue to be enforced by the judge, by her jurisdiction. That was one of the conditions of the stay. Abeyance, yeah. All right, reader's choice. You can pick your accent. All right, so here we go. Back into it. So now that we remember what Judge Chutkin wrote here, hopefully. Enhance, sticker, select sticker. Okay, look one more time. Okay, we'll see. Enhance, sticker, pick a sticker. Hold on, everybody. Let's see. I think I might have gotten it. How long does the sticker last? Oh my gosh, I'm so excited. Okay, everybody, did we get it? Wait, is it there? Nope, it's not. Shoot, where'd my sticker go? Somebody's gonna get a sticker somewhere. Is it on the screen? Do you see it? Is it? It was there. I know it was. All right, I'll try one more time, everybody. Oh my gosh, this could be life-changing. Hold on, everybody. Let's try one more time. Okay, one more time. Stay with me. Oh my goodness. All right, here we go. One more time. Okay, here we go. Sanctions. Okay. Oops, sorry. Can you guys... Okay, here we go. One more time. Thank you for all being so patient with me. I really do appreciate it. All right, here we go. Last time, everybody. If it doesn't work, we're moving on. And I will accept defeat. Defeat! Okay, here we go. Is it there? Is it there now? Can you see it? Do we have it? No, where'd it go? Oh my goodness, it's there. Is it still there? It's gone. Is it gone? It's now gone. Oh my goodness, everybody. Oh, it keeps disappearing. All right. Well, we tried. Oh my gosh, thank you all for being so kind about it. I appreciate it. Oh my gosh. Okay, I'll keep working on it. I don't know. It's yeeted. It's like, I do not want to be on this document today. Oh my goodness. Oh my goodness. All right. So kind, everybody. I appreciate your patience. So I will put that on hold then, but appreciate that. I'm going to have to do some research on that. But thank you, everyone, for your wonderful support. I'm very, very thankful for that. Oh my gosh. All right. Back into it. So where were we? Here we go. To ensure that the prosecutors did not incorrectly believe that the court had tacitly, okay, forget it, endorsed its lawless request for in absentia proceedings, the court provided two and only two limits on the stay. Maybe try it at the beginning. Tacit, thank you. Tacitly. Tacitly. I'm struggling a bit today, everybody. It's been a rough morning. All right, stating that 1, the state deadlines in proceedings are to be held in abeyance here rather than permanently vacated, and 2, the court does not understand the required stay of further proceedings to divest it of jurisdiction to enforce the measures it has already imposed to safeguard the integrity of these proceedings. Okay, so we do have a quote of that particular part of the order, so that's good. Tacitly. Okay. Oh my goodness. All right. Driving this point home, the court distinguished the above exceptions, which it held do not advance the case towards trial or impose burdens of litigation on defendant beyond those he already carries, from additional discovery or briefing, which do impose such burdens. Okay. And what word are we missing here? Let's just take a minute. What word are we missing? Okay. So let's just make sure here. Unlike, for example, the next sentence, requiring additional discovery. So we're missing the words requiring and additional. We'll see if he hits on those. We'll see. Right. Oh my goodness. Despite this clear guidance, well, I don't know. I don't know. The prosecutors immediately violated the state order by serving nearly 4,000 pages of additional discovery, which was not required, on December 17th, including what the prosecutor's production letter described as several hundred video and audio recordings. So let's pause just for a moment. So he got this discovery December 17th. And so this order came out staying everything here on December 13th. So it was 4 days later. Now, 4 days later, we have, I think I see a problem, everybody, and I think it's because I'm a little spicy today. So let's just write this date down here. We have the 13th. I can possibly see where his First Amendment issue is, because I don't think he knows what immediately means. Now, if you've got an imminent lawless action that you're encouraging people to do under Brandenburg, your speech isn't protected. And that means they're there at the time and immediately doing it. Here, immediately apparently means 4 days later. All right, moving on. The next day, on December 18th, the prosecutors continued their brazen misconduct by serving a purported exhibit list. What? Oh my goodness. The prosecutor's only explanation for this harassment. What? Now this I know is not a legal argument. That is not a legal argument at all. Oh my gosh. Trump was their already rejected claim that violating the state order was necessary to help ensure the trial proceeds promptly if and when the mandate returns. All right. Worse, the prosecutors misrepresented the state order, claiming that only the deadlines in the pretrial order are held in abeyance, when in fact the court stayed the deadlines and proceedings scheduled by its pretrial order. Oh my goodness. And held that any further proceedings that would move this case towards trial or impose additional burdens of litigation on the defendant are prohibited. All right, there we go. Deadlines and proceedings. That's the question. Is giving someone discovery a proceeding or filing a motion in limine? All right. Thus, the prosecution's claimed justification that continued filing and discovery are necessary to prepare this case for a potential trial is precisely what the stay order forbids. I'm not sure it clearly says that. Trump patiently explained this to the prosecutors. Whoa, what is this? What? Is this a closing statement to a jury here? Patiently. Oh my goodness. Well, we're not at trial right now. There is no innocence until proven guilty. we're in administrative motions. That's where we're at. All right. So he was very patient. Good for him. Oh, user. Oh, bye-bye, user. Oh my goodness. All right. The spice is strong today, everybody. All right, both in a response to the prosecutor's notice of service and a separate letter. So let's take a look at the letter, everyone. All right, so again, he patiently explained it. So let's see if that's in the letter here. There is no question that your present discovery and draft exhibit list productions and any future productions are proceedings that violate the state order by advancing the case towards trial and imposing additional burdens of litigation on Trump. Indeed, the prosecution admits as much in its filing this evening, which states it produced the draft exhibit list to help ensure that trial proceeds promptly if and when the mandate returns. Now, again, this is a draft exhibit list. Both the stay order and binding precedent forbid these unlawful actions. All right, so he is stating then that discovery is a proceeding. Did everybody catch that? Okay, so discovery and a draft exhibit list are proceedings then, according to him. All right. Right. I'd love to hear it, Mads. Although the prosecution may wish to rush this case to an early and unconstitutional trial in hopes of undermining Trump's commanding lead, it's commanding, in the upcoming presidential election, it must nonetheless abide by the stay order. As such, we will not accept or review the present production or any additional productions until and unless the court lifts the stay. If the prosecution continues to violate the stay, we will seek appropriate relief. So, do you think he's patiently explained this? Is that correct? Are they using AI? Oh my gosh, I'm not sure. There have been some questions about who's been writing things. Oh my goodness. All right. And yes, I have read this, but no, it's just pseudo law, pseudo legal arguments. So I will stick with the facts. The prosecutors did not respond to either the letter or the response. The prosecutors did, however, attempt to wrongfully exploit the state order. Oh my gosh. Oh no, not the exploitation of the stay order. Oh my gosh. First we weaponized the stay, everybody. Now we are exploiting the stay. So we got to stay up. Oh my gosh. The stay order in seeking certiorari before judgment from the Supreme Court. Namely, the prosecutors advised the Supreme Court that 1, Trump's appeal has halted progress towards trial, right? 2, the effect of that appeal, as the court recognized, is to automatically stay any further proceedings that would move this case towards trial or impose additional burdens of litigation on President Trump. And again, their ideas, discovery is a proceeding. And 3, the deadlines and proceedings specified in prior pretrial orders are stayed. So the deadlines and proceedings, which apparently means discovery to Mr. Trump. And 4, in short, the case is now on hold. All right, so that was in the petition for a writ of cert. I'm confused. I feel like I have whiplash. I know it's hard to keep up. Nowhere in this recitation did the prosecutors adopt their discredited and unsupportable claims that only deadlines and not proceedings are stayed, or that they are somehow permitted to continue advancing the case towards trial through preparatory filings or discovery productions. What? Oh my goodness. So I'm going to tell you right now, if the court comes back and is like, you're right, discovery's a proceeding, I'm going to need to take a break. I'm going to need to take a vacation. Oh my gosh. Just the opposite. The prosecutors argued that the stay order was effectively all-encompassing and therefore necessitated urgent intervention by the Supreme Court. I recommend reading that cert again, but whatever. Unpersuaded, the Supreme Court denied the prosecutors' desperate ploy. Oh my gosh. Seriously, what is this? These words, man. Words are important. Words hurt, people. All right, yes, tea break, thank you. I can't. Oh my gosh. Oh, sheesh. Maybe it's a little too early in the morning for me. Okay, so I'm not sure that language is necessary, but whatever. Having failed above, the prosecutors resumed their strategy of violating the stay order. Oh no, they violated it. They weaponized it, they exploited it, and now they're violating it. It's a lot. The stay orders really having a go of it. Filing the motion in limine on December 22nd of 2023. Aware that their submission was improper, the prosecutors tellingly did not confer with President Trump before filing as required. What? All right. Second minute order here. We're citing that. Moreover, and unsurprisingly, the prosecutors suddenly forgot their histrionics. What? They suddenly forgot. Regarding the all-encompassing scope of the stay order. So again, there's two parts to the stay order. Oh my gosh. Instead, the prosecutors returned to their twisted view that the stay order is merely a suggestion. Again, that's not necessary. Meaning less than the paper it's written on. Who says that anymore? But okay. Once again, the prosecutors falsely claimed that only deadlines are held in abeyance, and not any further proceedings that would move this case towards trial or impose additional burdens of litigation on defendant. And once more, the prosecutors admitted their goal is to achieve exactly what the stay order forbids. What? Again, we're writing a fiction novel, everybody, preparing this case for a potential trial, which the prosecutors arrogantly presuppose will occur. I'm circling all of the unnecessary words. Oh my goodness. They talk in circles, right? And half the words they use are from some kind of a fictional, not worth the laptop it's on. That's a good point. Yeah, what do you mean paper? I'm the only one that uses paper. Nobody else uses paper. Oh, my goodness. Emotional hot words. Yeah, I mean, but not even appropriate. See, all right. There's more to it. There's more. Let's see. They read the cheap novels. Sometimes the cheap novels are the best novels, but not the best ones to write your brief off of. All right, yep, this is not the prosecutor's only unlawful goal. Instead, again, here's another trigger word, unstated but obvious is the prosecutor's desperate effort to harass Trump and prevent his likely victory in the 2024 election. A significant part of the strategy, which the prosecutors have employed from the outset, is to use this case as a platform to advance the Biden's campaign. All right, now we're getting into ethical concerns again. So remember, the ethical rules says if your argument has no basis in the law or in facts and can be seen as frivolous, it is unethical. All right, so advance the Biden campaign's dishonest political talking points, which is insulting to the district court, including, for example, echoing the false and defamatory claims that Trump spreads disinformation, claiming Trump propagates irrelevant disinformation here, okay? Okay. Biden campaign officials say they are injecting our message into GOP primary coverage and plan to combat mis and disinformation about President Biden that may appear on Trump's social media platform. Okay. Likewise, the prosecutors dutifully repeat the Biden administration's long debunked claim that Trump somehow caused the events of January 6th. So, when in truth, President Trump called only for peaceful and patriotic protest and assembly. Now, let's just see what we are citing here, because this is, as we all know, not true. That is not correct. It has not been debunked, first of all, so let's just clarify that. What's he citing? Transcript of Trump's speech at the rally before the U.S. Capitol. So this is fascinating, everybody. He's saying, hey, I asked for peaceful and patriotic protest, but yet, where is the rest of his speech with other inflammatory words like take back your country, fight like hell, those kinds of words? Those were also in the speech. So we're really cherry picking our words. Lawyer be disbarred. The violation have to be more severe. The violation would have to be more severe. I think if they take all of this into consideration, all of the motions, all of the unethical things, at the end of all of this, it could rise to the level of a potential loss of license, but that would be the most severe sanction that you would have. Mm-hmm. He does tell them to go home. That's right. He told them to go home in a tweet 4 hours later, right? Mm-hmm. That's true. I'm wondering why they haven't cited that. All right, here we go. Encouraging the crowd to peacefully and patriotically make your voices heard and cheer on our brave senators and congressmen and women. Claiming Trump was responsible for inflaming followers and causing the Capitol riot. Now, I have read through this speech on a live, and we watched the speech on a live, and yeah, that speech was like long. I mean, there were a lot of words in the speech. So we have another citation. Los Angeles Daily. President Joe Biden forcefully blamed Trump and his supporters Thursday for holding a dagger at the throat of democracy with election lies that sparked last year's deadly assault on the U.S. Capitol. All right. Okay. He loved them. They are very special. Yeah, it takes a special person to do what was done. As it did on Truth Social, the Biden campaign improperly seeks to inject its message into this case, which, by the way, is the exact language that Jack used in his appeal. And the prosecutors are more than happy to oblige, notwithstanding the stay order. Indeed, as the prosecutors undoubtedly anticipated, the political talking points they strategically placed in the motion in limine spread like wildfire. So, political talking points. This is a good question. Are the points that he brought up, the legal questions and legal arguments he brought up in the motion in limine, they are also political talking points. So they are both. They're legal arguments and did become or had become political talking points. So that's an interesting point. They strategically placed in the motion in limine, spread like wildfire. Again, this language, reaching every major news outlet in the country within minutes. Here, and then we've got citations to CNN and other places. What's this? Washington Post and ABC News. Everything political. Yeah, I mean, there's a lot of politics involved, but, you know, it can be both. It can you not use legal arguments that sound political? But on the other hand, you know, Jack is saying in his motion in limine that he doesn't want the political questions to be raised in front of a jury. So now we're dealing with a different issue. So we've got a motion to limit his political arguments in front of a jury versus, you know, what someone in the public can take out of a motion filed. So I think those are distinguishable. All right, applicable law. Courts possess inherent power to enforce compliance with their lawful orders through civil contempt. All right. All right. Doing so is essential to the enforcement of judgments, orders, and writs of the court, consequently, the due administration of justice. All right. Accordingly, a party moving for civil contempt must show by clear and convincing evidence that, one, there was a clear and unambiguous court order in place. So let's go through these. Do we have a clear and unambiguous court order, everybody? Let's just poll the audience. I'm polling you here in the comments. Do we have a clear and unambiguous court order by Judge Chutkan? First question. No. No. Okay. Yes. Okay. Okay. Yes. Yes. No. Yes. Oh, yes. We do have a clear order. Not at all. Okay. All right. So we don't know. There was a clear and unambiguous court order in place. Number two, that order required certain conduct by respondents. So did her order staying it require certain conduct? Oops, I mean yes. Oh my gosh. Stands for is not so clear. So is Judge Chutkan setting out conduct here? So let's just note this here. The court does not understand the required state of further proceedings to divest it of jurisdiction to enforce the measures it has already imposed to safeguard the integrity of these proceedings, including defendant's conditions of release, the protective orders, governing discovery materials, restrictions on extrajudicial statements. So is she giving a command there with her language in that part of the order? The argument's ridiculous. It's kind of gray. Yeah, I think we're in shades of gray, everybody. I think we are in shades of gray. And I think, I don't think she did a proactive conduct that was done. She stayed the proceedings, so she paused everything. But is that specific conduct? Was she forbidding anyone? Negative ones, but points nonetheless. Right. Right, exactly. I'm not sure. Is she giving proactive conduct? So that's a question. And number three, respondents failed to comply with that order. So that's the third question. Did Jack fail to comply with her order of staying the situation but retaining jurisdiction over some things by giving discovery to the defendant, filing a draft exhibit brief or giving him a draft of the exhibit list and filing a motion in limine? No, I don't think so. No. Okay, no. Yeah, we don't know. Oh, we don't know. She did not say halt any new discovery. Exactly. She certainly did not. And it certainly wasn't clear and unambiguous. There was no statement in there specifically on that. Her only statement about discovery had to do with protections that had been put in place. All right, so we're not sure about that, but there you go. Here we go. Once the moving parties made a prima facie case demonstrating that the respondent failed to comply with the court's order, the burden shifts to the respondents to produce evidence justifying its noncompliance. So we've got two phases here. We have to have a prima facie case, which just means enough information to go forward. The respondent's intent in failing to comply with a court order is irrelevant. However, respondents may justify their failure to comply with a court order by establishing their inability to comply or good faith substantial compliance. To demonstrate good faith substantial compliance, the respondents have to show that they took all reasonable steps within their power to comply with the court's order. And this to me just seems irrelevant. I'm not sure why they included that. Right. No. I know. She may take control to keep things on track. Yeah, exactly. This is supposed to help the entire well, right. That's not really how that works. All these judges. Well, I think they're being careful. And understandably so, but are they being too careful? Well, that I don't know. It seems like it, but again, I'm undecided. Although President Trump's notice of appeal divested the court of jurisdiction regarding the substantive aspects of this case, the court held that it retains jurisdiction to enforce the measures it has already imposed to safeguard the integrity of these proceedings. It is currently unnecessary to decide whether the court retains such residual jurisdiction over certain prior orders. Wow, that to me seems like the biggest argument. However, there's no dispute that the court retains jurisdiction over the stay order itself, and thus any contempt proceedings flow from the prosecutor's violation of the stay order. What? Citing case law, collecting voluminous and convincing case law that a district court possesses jurisdiction to enforce its orders pending appeal. Okay, I mean, that's like writing, we have an alphabet with letters in it, including through the civil contempt proceeding unless a stay of those orders are entered pending appeal. All right. Okay. Oh, now we're getting into the argument, everybody. What? We haven't even got into the argument. That's just the applicable law. Oh my goodness gracious. We haven't even started the argument. Oh my gosh. Oh my goodness. All right, I'm gonna need a drink of tea here. I need some. We've only got a couple pages left, so. Oh my gosh, 7 hours later. What? All right, I'll skip through this next part a little bit quicker, so just a minute. Oh my gosh. Yeah, DC, I'm crying too. All right, well, never mind, everybody. That was the applicable law, apparently. That was not their argument. What? Their applicable law is. Yikes. All right, here we go. Argument. The court should order the prosecutors to show cause why they should not be held in contempt. Okay. As with other orders, the court may remedy the violation of a stay through civil contempt proceedings. Citing case law. A violation of the automatic stay may be redressed by the bankruptcy court under its civil contempt powers. What does that have to do with anything? Oh my gosh. First of all, everybody, let's just take a minute here. Okay, we've got a Westlaw citation. We've got a bankruptcy citation out of the Eastern District of Virginia from 2008. What is happening here? What is this? A violation of the automatic stay may be redressed by the bankruptcy court under its civil contempt powers. I don't even know what that means. Oh my gosh. Somebody pull the citation. I don't know. Oh my goodness. Is this even a case? I don't know. Oh my gosh. In Ray Walker here, a bankruptcy out of Maryland. What is this? Oh my gosh. Beyond undermining the court's jurisdiction, a violation of the automatic stay constitutes contempt of court. For what? In Georgia? What are you talking about? All right, this is getting ridiculous. All right, here we go. In Ray, again, bankruptcy court, Maryland, 1982. Noting nearly unanimity that the knowing violation of an automatic stay is contempt. All right. All right. Oh, wait, Middle District of Georgia. Oh, my gosh. They forget which trial they're in. Right. So you can use all kinds of case law to help support you. But if you have a basic contempt issue in a criminal federal case, there should be federal law out there regarding contempt. So I'm not sure why they didn't use that instead. Oh my gosh, make a drinking game. I don't know. I don't think we'd make it, everybody. Okay, here the prosecutor's repeated and willful violations of the stay order warrant contempt. First, all right, get ready for it, everybody. There was a clear and unambiguous court order in place. And see, this is a proper citation. Is this a real cite? I don't know at this point. I have doubts. But it's a federal citation. Citing the automatic divestiture rule in Griggs, the prosecutors initially urged the court not to enter the stay order, claiming that doing so would be unnecessary and duplicative. Okay, again, hashtag what's the relevance? Wait, I'm not allowed to say the hashtag. That's so 2010. What are you doing? I'm like, okay. All right. It's now clear that the prosecutors planned from the outset to violate the stay. Ooh, is that ethical? I don't know. Again, everybody, is there a basis in law or fact? And if not, if it's seen as frivolous, bad faith, it can be an unethical statement in a pleading. They mistake the argument with the case law. Yeah, I think so. I think they might have their parts swapped. I'm not sure. And only wish to avoid a court order specifically forbidding them from doing so. Seriously, is this ChatGPT? Seriously? I mean, oh my goodness. This is ridiculous. Wisely, the court, wow, again, inflammatory. The court did not leave the prosecutor's obligations under the stay to chance or interpretation, but instead issued a straightforward order that allowed only one category of litigation, the enforcement of existing orders. Now, she specifically said there were two, but whatever. Likewise, the court was equally clear about what would not be allowed. All other proceedings that would move this case towards trial or impose additional burdens of litigation on defendant, including all deadlines and proceedings scheduled by the pretrial order as amended. In setting these boundaries, the court, that's a great phrase that I think would be great if they really knew what that was. The court was explicit. Both additional discovery, required additional discovery, and briefing on non-accepted topics would violate the stay order. Well, that's interesting. So they're saying accepted topics then would not violate the stay order. So they just contradicted their entire argument. Okay. All right. Let's go back again. These attorneys. Oh my gosh, read it. I can't get Trump's voice out. I think it'd be too much for the spice today. In setting these boundaries, the court was explicit. Both additional discovery and briefing on non-accepted topics would violate the stay by improperly advancing the case towards trial, wrongfully imposing burdens of litigation on defendant. Proving the clarity of these instructions, the prosecutors accurately explained the scope of the stay order to the Supreme Court, bemoaning, that's triggering, inter alia, the case is now on hold together with all deadlines and proceedings. Thus, there is no doubt the stay order is a clear and unambiguous to everyone, including the prosecutors. And we're citing, again, this case. Second, so that's their first argument. Second, the stay order required certain conduct by the prosecutors. So I feel like their previous section here, where they're going through the standard of law, was their argument, and now they're in their conclusion, is kind of how this seems, is how it's written. Can't hand in your homework early. True story. Specifically, the stay order required and requires that the prosecution abstain from attempting to move this case towards trial or impose additional burdens of litigation on the defendant. So I think that's the 7th time they've quoted that. Although the stay order does not require the prosecutors to perform certain acts. Okay, everybody, hold on. We have another admission. All right, so hold on. Let's take this back for a minute. You're going to get the full legal analysis. No extra charge today, everyone. All right, remember we had to go through this test regarding contempt. We went through our 4 factors to make a determination. There was a clear and unambiguous court order in place. That order required certain conduct by respondents. Well, let's take a look here. Although the state order does not require the prosecutors to perform specific acts. So wait a minute. Did we just say that no commands were given, even though that's required under their case law for contempt? Is everyone following me on that one? That's a lot. You don't want to answer or pose your own arguments in your own motion. I mean, I don't recommend that. Bracketing words. Yep. Okay. Oh, my goodness. All right. So a party is in contempt of court when he violates a definite specific court order requiring him to perform or refrain from performing a particular act or acts with knowledge of that order. Now, let's see what we're citing here. This is a new case that we're citing out of D.C. Here, there is no, again, this citation is in conflict with their other citation. The Broderick citation, all right? There is no reasonable doubt as to what behavior was expected and who was expected to behave in the indicated fashion. So again, behavior versus the test requiring certain conduct. So, all right, here we go. Number 3. The prosecutors failed to comply with the stay order. The party seeking a finding of civil contempt must make a prima facie showing that the putative contemner has violated an order through a showing of clear and convincing evidence. And they're citing the previous case that just put out behavior. Citations here. In this case, there's no doubt, despite the court's explicit holding that additional discovery and briefing would violate the stay. That is incorrect, actually. That is completely incorrect language. They're here. So they're saying, this is Judge Chutkin's order. Requiring additional discovery or briefing, maintaining those measures does not advance the case towards trial or impose burdens of litigation on defendant beyond those he already carries. So she gave an example here. So let's read through this again. In this case, there's no doubt, despite the court's explicit holding that additional discovery and briefing would violate the stay order. All right, I flipped it backwards. So I guess this is okay. They're flipping around what she's saying by saying the examples set out what would violate the stay. The prosecutors repeatedly engaged in that exact conduct, disobeying the stay order at least 3 times in just 2 weeks. All right, so this is such a mess here. By themselves, each of the prosecutor's violations, including a large discovery production, again, we're going through what they gave, an extensive exhibit list production. This was a draft, by the way. Keep that in mind. And a lengthy motion in limine briefing would be substantial and warrant sanctions. And that's a conclusion with nothing to back it up. Taken together with the prosecutor's threat to continue violating the state order indefinitely, there's no question here that the prosecutor's actions and purposefully contemptuous. Conduct is beyond the pale and must be sanctioned. So that's what they're requesting here. Again, so, all right. I'm trying to not get tangled up too much, but this whole paragraph seems to me like is completely unnecessary. How is this even an argument? So if we're just looking at it, the prosecutors failed to comply with the stay order. So they're citing here a case saying that the defendant has to make a prima facie showing that the violators violated the order through clear and convincing evidence. All right, so there's the law that they're citing. So despite the court's explicit holding that additional and briefing, so they're pulling out 3 words from her order, would violate the stay order, the prosecutors repeatedly engaged in that exact conduct, disobeying the stay at least 3 times in 2 weeks. So they're setting out, again, everybody, follow me down the rabbit hole here, people. So we've got number 1, they have to show on clear and convincing evidence that there's a problem. And they're saying she wrote these 3 words in her brief or in her order, and that they engaged in that exact conduct within 2 weeks. That's their clear and convincing evidence. So each of the violations includes, again, large discovery, an exhibit list, a draft, and the motion in limine. So those 3 things are clear and convincing evidence that they violated it. Watching a teacher grade an F paper. It's very frustrating. Oh my gosh. All right, moving on. That paragraph's just a bit messed up, but we'll move on. 4th, the prosecutors have no justification for their misconduct. So if they have to prove by clear and convincing evidence here, why are we here with that as well? So that's another question. As noted, intent in failing to comply with a court order is irrelevant. So that doesn't even make sense. So the prosecutors have no justification, but yet their intent or failure to comply is irrelevant. So they just said they don't have a justification, and any justification's irrelevant anyway. I don't even understand what that means. However, even if intent were a consideration, the prosecutors did not violate the stay order inadvertently. I think that's a bit of a stretch. Let's see what evidence they have. President Trump explained the scope of the stay order to the prosecutors. What? And warned them to stop their violations. Did he? Oh my gosh. Oh my gosh. That's a lot. Oh my gosh. Well, I'm glad he was able to explain the scope of the stay. Oh my gosh. Was this written by Nada? I don't know. I can't. You think so? I don't even know. Oh my gosh. I'm going to need them to go back to law school. Oh my gosh. All right. Afterwards, we're almost there, everybody. We're almost done. Afterward, the prosecutors submitted a brief to the Supreme Court demonstrating that they knew full well that what the court expected of them. So this, again, just shows that they're upset that they filed with the Supreme Court 2 hours after on a tweet, 4 hours in a speech. Oh, my gosh. Yes, I'm glad he's here as well. Yes. I don't know. Some of those dollar store attorneys are really good, actually. Really good. They don't get enough credit. I'm just going to say, don't put down the dollar store attorneys. Yet they violated the stay order again. These were no accidents. All right. The submissions were fully planned, intentional violations of the stay order, which the prosecutors freely admit they perpetuated in hopes of unlawfully advancing their case. All right, again, so let's go back. The prosecutors have no justification for their misconduct. Intent in failing to comply with an order is irrelevant. So they're starting out by saying there's no justification and it's irrelevant. And now here they're saying they intentionally, unlawfully were advancing their case. What is that? That's just, oh my gosh. I can't. Yikes. For the same reason, the prosecutors cannot show they took all reasonable steps within their power to comply with the court's order. So again, what can the prosecutors show? I'm not sure. Because apparently they refused discovery. How would they know what the prosecutors can show? For instance, the prosecutors never sought any clarification of the order, and neither did the defendant. Apparently he's the one with the problem, and never asked permission to make any filings. Who asked for permission to make filings? What? That's not a thing. That's not even a thing. Oh my goodness. Who answers this? The judge. Oh, well, all right. So this is a motion asking for a causal showing for sanctions. So I would say the government can respond back to this, and then there could be one more reply from the filer or the moving party. The court could set it for hearing. Oh, my goodness. Mommy didn't ask permission. Oh, my gosh. This isn't a thing unless you have a court order that specifically sets it out, which is incredibly rare. Likewise, recognizing that their actions were plainly unlawful, the prosecutors purposefully did not confer with opposing counsel before filing the motion in limine. Again, anytime I write law or fact is where I've got a question under the rules of professional conduct. Under Rule 3, that could be a ding for them. These repeated intentional and malicious actions demonstrate, okay, so that the prosecutors have not once attempted to comply with the stay order. What? Not even once? That's a lot. But have instead openly defied it from day one. But wasn't it 4 days later when they offered discovery? Day one, nobody filed or did anything. So that's not true. You mean day 4. You don't quote the footnote on the page 1 of the discovery. You know, it's a lot. It's a lot. It's a lot, everybody. This one's a lot. Okay, accordingly, the prosecutors did not take all reasonable steps to comply with the stay order and therefore were not in good faith substantial compliance with the order. So, hold on. Accordingly, the prosecutors did not take all reasonable steps, but let's back up again. Malicious action demonstrate that prosecutors have not once attempted to comply, and they did not take all reasonable steps. Like it's the same sentence spit out 4 different times to make a paragraph. So that would be no points on that one. Is their criminal equivalent for the Federal Rules of Criminal Procedure 11. So let's take a look. Let's take a look and see. Federal Rule of Criminal Procedure 11. Entering a plea. We have to be more specific. Did I see that right? Rule 11? Federal Rule of, or Civil Procedure. Are you talking about the Civil Procedure Rule 11? Coming in on a rule. Oh my gosh. All right. Signing pleadings, motions. Okay, there we go. Civil procedure. I was like, wait a minute. We've got pleadings. That's a different kind. Signing pleadings, motions, and other papers, representations to the court, sanctions. Is there a criminal one? So, no, there's not. If there was some kind of like malicious conduct, it would have to rise to the level of harassment. I would have to rise to a level beyond that. That's why we put it in the civil world as opposed to in the criminal world. That's a great question. Every pleading, written motion, or other paper must be signed by at least one attorney of the record or by a party. And then representations to the courts here, again, whether signing, submitting, an attorney or unrepresented party certifies that to the best of that person's knowledge, information, and belief formed after an inquiry reasonable under the circumstances, that it is not presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Yeah, we have all of those things going on here. So no, we should though, shouldn't we? We should have a criminal sanction. We should vote for that. For C, should I go through C too? All right, let's take a look. Let's take a look. All right, Rule 11C, sanctions. After notice and reasonable opportunity to respond, the court determines that 11B has been violated. The court may impose an appropriate sanction on an attorney, law firm, or party that violated the rule or is responsible for the violation. Absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its partner, associate, or employee. So there you go. So we do have sanctions then if you are misrepresenting to the court. So that's what they're citing here, Rule 11B. So, and again, we've got 4 different things here. So the denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on a belief or lack of information. So I don't see how that would be. Then we've got a motion for sanctions on the court's initiative. On its own, the court may order an attorney, law firm, or party to show cause why conduct specifically described in the order has not violated Rule 11B, so that burden is flipped, and the nature of a sanction imposed under this rule must be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. To include non-monetary directives, an order to pay a penalty into court, or if imposed on motion and warranted for effective deterrence, an attorney's fee or other expenses directly resulting from the violation. Limitations on monetary sanctions, so we do have a cap on that. And requirements for an order imposing a sanction must be describe the sanctioned conduct and explain the basis for the sanctions. Inapplicability to discovery. This rule does not apply to disclosures and discovery requests, responses, objections, and motions under Rules 26 through 37. That's interesting. I didn't remember about the inapplicability rule to discovery. Yeah, I was going to say, I mean, discovery's got pretty much can do whatever you need to do. But again, this is discovery in a civil case. I'm not sure. I'm not sure how that would mean. He's stating until he can order more lawyers for, oh my goodness. Oh my goodness. All right. So great discussion, everybody. We've got Rule 11, Federal Rules of Civil Procedure here. So Federal Rules of Civil Procedure. I think that's a good point. That's an excellent citation. No sanctions for this response. I don't know. Wouldn't Chuckin have dinged Smith already if she thought he had violated? Yeah, could be. It could be. She could on her own motion. And again, it was a while ago. Keep in mind, this was just filed today. The motion in limine was filed the 27th. The discovery stuff was given even before that. So, I mean, our timelines here aren't quite working. All right. So with that, everyone, I promised I'd speed through, and then I've been lollygagging. So let me move along. All right. Here's the second argument. The requested sanctions would be appropriate. A civil contempt action is characterized as remedial in nature, used to obtain compliance with the court order or to compensate for damages sustained as a result from noncompliance. Thus, federal courts have broad equitable powers to craft remedial sanctions for civil contempt, and a court's goal is to fashion a remedy that will coerce the contemner into compliance, compensate the complainant for losses due to noncompliance, or both. The requested sanctions are sufficient but not greater than necessary to accomplish these goals. As an initial matter, the court should order the prosecutors to immediately withdraw their motion in limine and improper productions. That is just absolutely crazy land, everybody. We're in Crazyville. These are the primary violations of the state order, and they continue to cause additional harm to Trump and to the due administration of justice each day that they remain outstanding. So hold on a minute. He's a motion in limine. You're requesting evidence that's already available not be shown to the jury during trial. How is that continuously harming the defendant? Riddle me that. We need to have a dose sound effect. Oh my gosh. I mean, how does that happen? All right, so here we go. We're continuing to cause additional harm to Trump and due administration of justice each day that they remain outstanding. So as long as his motion in limine is on file, it's harming Trump in some way. But yet, once the case gets going again, you would still have that motion in limine on file. It'll hurt their feet. Oh my goodness gracious. Although Trump has, consistent with his rights under the state order, refused to accept or substantively respond to those violative documents. All right. The only way to obtain compliance from recalcitrant prosecutors, what is happening here? Such as these, is to force them to acknowledge their wrongdoing and affirmatively withdraw their offensive actions. What? Next, the court should require the prosecutor seek and obtain permission from the court before submitting any filings or productions for the duration of the state order to ensure that any further attempts to violate the state order will be summarily denied. What? The prosecutors have shown repeatedly that they are unwilling to act in good faith. That's not true. And have announced their intention to continue violating the state order if left to their own devices. A pre-clearance requirement will ensure that only permissible documents are filed or served while imposing minimal administrative burden. As such, documents should be very few and far between, if not existent. How does he get to decide what the prosecutor's going to file in his own criminal case? What? Oh my gosh, I can't even, this doesn't even make sense anymore. It's like someone's got a thesaurus and they're just flipping through random words. Who filed this? So this was filed by Mr. Trump. Now arguably helped Trump by giving him time. Well, yeah, I would say yeah, definitely, because he can prepare his arguments to go against it. Willfully withholding exculpatory evidence. Yeah, by giving it to the defendant. Oh my goodness. Last, the court should require the prosecutors to compensate Trump for damages sustained as a result from noncompliance. I don't know, but it couldn't have cost that much to write this motion. I'm just putting that out there. Namely, the prosecutors should reimburse Trump for all reasonable attorney's fees and other expenses he incurred responding to the prosecutor's improper proceedings, productions, and filings. This would include the cost of preparing his prior response letter. So he wants to be compensated for a response letter? What? And in preparing and litigating this motion, which is Not very good. Maybe $1.25. Oh my goodness. In this district, a contempt award will often consist of reasonable costs, including attorney's fees incurred in bringing the civil contempt proceeding. This is sensible, as attorney's fees and costs caused by an offending party's contumacious conduct. Oh my goodness. Is designed to compensate the injured party. This can't be a real person writing this. I think this can't be. It has to be. How would we check? If we just put in a paragraph, would we be able to find whether or not this was generated by that? I believe Trump wrote this during one of his night snacks. Yeah, ChatGPT, yeah, or AI. How would we be able to tell? Rather than punish the offending party, it's well established that courts may award attorney's fees and expenses in conjunction with a civil contempt proceeding. An award of fees is therefore entirely appropriate and necessary to remedy the financial injuries caused by the prosecutor's misconduct. Indeed, considering the equally significant harms the prosecutor's actions have imposed on the public by undermining the purpose of the stay, ensuring immune officials can confidently exercise their discretion. How is this a sentence? Is this even English? I mean, come on. Without fear of litigation, this request is quite modest. What? Oh my goodness gracious. We need to ask a teacher because they do it all the time. All right. Who's out there hunting down the GPT, the chat stuff? Disobedience towards judicial order. Oh my goodness gracious. Robot malfunction. Turn it in. Really? Okay, it's called language. Yeah, I mean, but I mean, I know the law language. Like, I know that language. This isn't in the language. This is not. Nor would a lesser award adequately deter the prosecutor's misconduct. The special counsel's office has spent untold tens of millions prosecuting President Trump. Actually, I think the majority has been on security for the prosecutors, including over $9.2 million in just approximately 4 months, again, for security, because of threats, and harm. U.S. Department of Justice here reporting approximately $5.4 million in direct expenditures and additional $3.8 million DOJ component expenses. Right. So let's just get that sorted. Has way more pontificating. Yeah, I mean, the other thing too, everyone, when you're sitting down to write a motion, or you're writing a pleading, yeah, we can get all flowery and we can use our fun language, but we will typically have a particular tone to get to a point where you are recognizing a particular attorney's style over and over again because they tend to use the same catchphrases and so on. But having these sprinklings of very odd words that we just don't use and that aren't in a lot of cases, it's odd. It's weird. We don't do that. Small claims filing. Although the prosecutors may scarcely feel the impact of paying Trump's reasonable attorney's fees, ouch, that's not very nice. Scarcely feel the impact. Oh my gosh. And expenses given the Biden administration's blank check. Ouch, that's mean. Again, I think that's unethical. That's an ethical question here. At the very least, it will signal that their continued violations will not come without costs. All right, conclusion. Goodness, it's been a long, tangly road, everybody, but we're going to the conclusion. Oh my gosh. Scarcely isn't even the right word. Oh my goodness. Yikes. Conclusion. The prosecutors are not ordinary parties to a controversy, but representatives of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. What? I mean, that's a good point, but I'm not sure. Like, why aren't they citing the bankruptcy cases again? You know what I'm saying? The prosecutors have cast these hollowed mandates. What kind of mandates? What? Seriously, everybody, I've got questions. Aside to score cheap political points against Trump on behalf of the Biden campaign. All right, so in doing so, the prosecutors have repeatedly and willfully disregarded the court's explicit instructions. Such malignant conduct, all right, I'm seeing a pattern here, undermines the integrity of this proceeding and warrants severe sanction. I found a good AI check, and no, that sentence isn't real. Really? Really? Oh my goodness gracious. No, we've cracked the case, everybody. We've cracked it. I just thought it was Giuliani writing this whole time. Oh my goodness. Oh my goodness. You should have an auction. You didn't have questions after. Well, exactly. His lawyer's making sure. Oh my gosh. This is a lot. Yeah, it's a lot. All right. The court cannot allow the prosecutors to continue to operate lawlessly in defiance of well-established protocol and this court's authority. Protocol? How is protocol relevant? I'm not sure about that. The requested sanctions are appropriate and likely to deter any further transgressions. And if not, the court retains the ability to impose more severe sanctions, including dismissal of actions. Citing this case, which is at least is a federal case out of 2010, a court has the inherent power to protect its integrity and prevent abuses of the judicial process, including the use of dismissal or default judgments as a sanction for misconduct. That's totally random. In citing another case, other inherent powers sanctions available to courts include disqualifications or suspensions of counsel. What? So he's offering discovery. What? And drawing adverse evidentiary inferences or precluding the admission of evidence. Citation omitted. Why is the citation omitted? Yikes. All right. So that's random. Oh my goodness. Accordingly, the court should order the prosecutors to show cause why the court should not hold them in contempt and impose the requested sanctions. All right, everybody. I need to go make a list of all the misused words. Oh my gosh. Wow, everybody. That was a journey. That was a mission. We completed the mission. But, you know, I don't feel particularly celebratory over this mission of terribly written yet again, a terribly written filing here. This is just atrocious. It's atrocious. It's out of order. The pieces are out of order. The citations are not very good, everybody, if they are legitimate. I still see the sticker. You do? The sticker's there? I don't see the sticker. Is it there? Oh no, is it right on the dot? Uh-oh, is it in a bad place? Oh my gosh. Suze, it is not. Really? Is there a sticker there? I don't see it. Looks like they wrote it last minute. I don't think anybody wrote it. I don't think anybody wrote this. It seems like a thesaurus and a random Google searches for court citations. So if you put in, you know, malicious conduct, what case is going to come up? So what are your first 10 hits on that? AI. I see no sticker. Okay, thanks, Linda. I don't see. Yeah, I don't think the sticker's there. I'm gonna have to educate myself. Seriously, I need to educate myself on that. What did I miss with the sticker? Right. So we're trying to figure out a better way to have what I'm reading up on the screen, everybody. That's what we're talking about. So I have various wonderful people trying to school me in how to do it. ChatGPT. Okay. Generated it and it's just edited so it would trick AI checks. Really? Okay. Took a screenshot. The sticker is there. Oh my gosh. Now only mods comments get pinned. Oh, I know. So I believe you, Suze. I believe you. I think I've completely got, I've messed everything. It's kind of gone bonkers. So here's my question then, everyone. Like Cohen got caught using AI. So Anthony, that's what I'm thinking too. So hold on. Let's pause for a moment. Let's have a pre-K pause. Let's pause for a minute. Now, Mr. Cohen, you know, like him, don't like him, whichever. Mr. Cohen is in a bit of trouble for using this AI chat GPT stuff. He's in a bit of trouble for filing and not going through and making sure everything was correct. But if that's like the protocol for the people that are using that, and those are the kinds of people that Mr. Trump hires as attorneys, I mean, I don't know. I think we can, is there an inference there? I'm not sure. But I think it's difficult when new technology comes out and yet, there's so many dinosaur attorneys. I mean, no offense, I'm halfway to a dinosaur myself, and they don't know how to use it and they don't know how to double check it. So, what do they have? They have some kind of an intern in their office that's like spitting this stuff out saying, no, it's fine, because they don't understand how it works. That's a valid question. Right on point. Yeah. Well, I mean, innocence or guilt isn't really what we're looking at. Right now, we're just looking at poor legal writing. Oh my gosh. I'm no lawyer, and that's honestly disturbing. No. Can you make the font darker? I can't. I wish I could, actually, at this point. Majored in opera, and I know dinosaurs. You're not even close. Really? Okay. Shoo. Oh my gosh. Yes. Well, you know what I mean, though, right? Like, there are some attorneys, and no offense. It's that, as technology develops, you have to get quicker and quicker. Like for me, for example, I can't figure out how to put a sticker on a live. You know what I'm saying? So how are they supposed to get into the complicated world of Chat GPT and figure out how to double check and make sure that everything is proper? But at a minimum, it seems like, stop flipping through the thesaurus and use words that we use in the field. Shouldn't a legit dinosaur attorney have rejected? Yes. Well, I'm not sure. Anymore. Trying to work. You're making it very difficult. John! That's funny. They need to use their helpers. Try the hazel eye. I'm telling you, I have to go 2 or 3 times in order to get all filters off of this. There are a few filters that I've had on before that I've had to come and get back off. Taking one look at this, rejecting it. You got the sticker, it just didn't say. It must have had a time limit. Yeah, I'm going to research that. I'm excited because we at least got a bit of it. Yeah, they're aids. That's what I'm thinking too, Jennifer. I'm thinking so. Why is everything funny to you? I think it's important to laugh because, we're on the precipice of a very disturbing situation. So if you can't laugh, what else are you going to do? Can you get attorney's fees in criminal cases? Yes, you can. You absolutely can. Mm-hmm. Oh, wait, was that, did the mods already grab him? Oh my gosh, the moderators. On Android, and I see, oh really, Seuss girl. Oh my gosh, maybe it does matter if you're on Android or not Android. You've got to laugh though. Well, you do. You really do. I mean, it's also, you've got to be able to find humor in all situations. And quite frankly, this is funny. I mean, in my opinion, legal writing, this is hilarious. And, many times I've had students that have submitted different writings that were required, and they're just so interesting. It's like, hey, that's a really interesting idea. But I've not come across any student ever at this level of ridiculousness. So how can you not laugh? How can you not? Oh my gosh. Typing. Oh, okay. Oh, well, sometimes we have accidents with the muting, but my moderators are incredibly diligent. They work so hard to make it so that we can have a pleasant learning experience. So we really should laugh. Well, say nasty things. Well, yeah, it's okay. It's okay. I think it's a good point, though. I've had several people that have commented on, my laugh multiple times. And again, I make no excuses other than to say that's just, that's my style. Take it or leave it. Take it or leave it. Like a kindergarten attorney. Oh, I love it. I love that, Marina. That's fantastic. I think that's wonderful. And, you don't have to be an attorney to protect your rights, but the more knowledge you have of the law, the more rights you know about, and the more ways you understand how the rules work, and that can do nothing but be helpful. Mm-hmm. I cackle. I've accepted it. Try it all the time. English teachers are pretty good. Well, that's what I'm thinking too. I'm wondering, I'm going to have to do a little bit of research. You know, we kind of had a heads up on the Cohen situation in the legal world. We had a heads up that that was coming down the pipe. So we knew that that was on its way. And so I may contact, I've got a couple people I could talk to about that. So I may ask them about this. It's cute. Well, snorts when she laughs. Oh, you're lucky. You're lucky to get a snorter. That means they're extra fun. Extra fun people. For sure. What was the point of the background section? Great question, Cecilia, and I don't know. I don't know. This filing doesn't make sense. It doesn't make sense. So we've got, there's several things in here. We've got multiple pieces that are kind of left hanging. So they walk down the road and then they just walk away. There is no evidence really supporting anything either. They're just saying the same three things over and over and over again. We have discovery, we have a draft of an exhibit list, and we have a motion in limine. So those three things, they're saying violate it, but they're just saying because those things are proceedings. And that's the other part of it where, like, I'm not sure discovery is a proceeding. I'm not sure. That's where it's at. And then, of course, we have, and I really didn't even start circling the language that was starting to be a bit questionable until page 3. So we start seeing this dip with all of these very inflammatory terms, but not like classy inflammatory, just like cheap shots and thesauruses terms, but not like classy inflammatory, just like cheap shots and thesauruses. It's like, what are you? Hold on, everybody. Hold on, just a minute. Sometimes I forget how many battery packs I go through. I have 3. So hold on. Let me get this one. Yikes. Let me get this last one. Set up. Just 1 minute. I need another set of hands. Hold on. At least I know how a battery pack works. At least there's that. Okay. So, oh my gosh. I don't know. My battery pack isn't working. Hold on. Love listening to you. Oh my goodness gracious. All right, well, just 1 minute here. This is the high level of production that we have. Yep. Do you have an outlet? That's a great question. All right, it's back, everybody. We're back. The battery's back. Sorry about that. Hold on, let me get the light. Just a second. Oh my gosh. All right. I'm feeling confident here. I wonder if I've burned out so many battery packs. All right, here we go. Yay. And we're back. And with that, scare everybody. We're back. Yikes. Technical difficulties have come to an end. Yes. We're back again. So again, I've got so many battery packs. Now, if I had an outlet that was close by that I had a way to plug into, I would, but I don't, fortunately. I have multiple places where I do my lives, and this one has the best signal for today. So this isn't where I belong. Well, you are welcome, Jen, to join. I know we've got a lot of very different opinions out there and different ways of looking at things. So feed the squirrel. Mom gave me the boot. No. Bigly words. Extension cord. Yeah, I don't know, everybody. I've got to kind of figure it out. I'm really not, I'm halfway to a dinosaur, so I've got to get it sorted. I've got stickers and power packs that I need to sort out today. That's my to-do list. For sure. So with that, though, everybody, I think that's a good signal that I should go ahead and sign off for now. I been on for a couple hours now. Do want to save some voice for tonight. I do plan to go at 7 tonight. I have plenty of voice, actually. Should, as long as I'm hushed for the rest of the day. All the stickers, yes. I'll see if I can get it figured out. So I will be back again tonight. We will do any updates that have happened. I will update you on anything that's been filed, and we'll kind of go through different things then. So thank you all for coming. It's always great to see you. Thanks for hanging out with me in our fun daytime live. So I will be back again tonight, 7 o'clock. If Trump needs immunity, why if he's innocent? It doesn't matter if he's innocent or not. You want to try all of the different ways of not going to prison that you can. So if that means immunity, then that's what you do. That's kind of the nature of the legal game. So this really isn't about guilt or innocence. It's about how you play the game. I wish I could tell you a different answer, but that's kind of how the law works. So yes, have a great afternoon, everybody. Thank you for, you're shooting pool tonight. Well, have a great time and good luck to you. So have a great time, everybody. I will catch you all later this evening then. Thanks again for hanging out with me and putting up with all of my ridiculousness. We'll see you all later.